Hi, in this third and final clip for this week, I would like to talk about non-international armed conflicts, or NIACs, which constitute an important but also complex topic for IHL. Important because some of the most bloody, most violent conflicts that we have in the world today are in fact internal conflicts such as civil wars, and it is arguably in such a context that the law of armed conflict would be needed the most. Complex because, as we know, international law is inherently state-centric, and the law of armed conflict is no different in this regard. In fact, the various treaties and provisions that were created at the end of the 19th century, early 20th century, and that includes also then later on the 4 Geneva Conventions that I mentioned in the first clip, were all created, all drafted with interstate conflict in mind. That said, and Klabbers explains this as well, there is one provision in each Geneva Convention that applies to non-international armed conflict as well, and that is specifically Common Article 3, which binds states to apply certain rules of international humanitarian law also in such a context. Common Article 3 is sometimes referred to as a mini-convention because it provides for a number of obligations that states have to follow, including to protect, to not target those who are not partaking in hostilities. It also reaffirms the humanity principle and provides for a non-discrimination equality guarantee in the application of this provision. It also explicitly outlaws a number of specific acts, including torture and murder, the taking of hostages, outrages against personal dignity, as well as summary executions. So just like a convention would do, it offers a sort of catalog of rights that are applicable to individuals, particularly those that are not partaking in hostilities. Now, while Common Article 3 is better than nothing, it remains a residual provision. And it very soon turned out that it did not provide enough protection to those who needed it within the context of internal armed conflict. And this is why in 1977, state parties adopted the second additional protocol to the Geneva Conventions, which created a more extensive and comprehensive legal framework to deal with non-international armed conflict. Looking at the second additional protocol, and as always, I encourage you to check out the legal instrument in question directly, you will see that it offers much more specific protections for those who are not anymore partaking in the hostilities, those who are hors de combat, as we say in international humanitarian law, and that in general the provisions are guided by considerations for the principles, as explained in the previous videos, of humanity, proportionality, and of course distinction. Now, while the substantive provisions of additional protocol number 2, while somewhat distinct, are still mostly comparable to the kinds of clauses that we find in the treaties pertaining to international armed conflict, the much bigger bone of contention with regard to NIACs concerns specifically when these provisions come to be applied. When is the law of non-international armed conflict, so to say, triggered? Here, it is useful to differentiate between 3 broad categories or situations, starting with the first scenario in which we might have internal tensions, disturbances, sporadic acts of violence, even riots, but these do not in their totality reach the threshold that would be required for it to qualify as an armed conflict. As a result, the law of armed conflict, whether that would be the Common Article 3 or indeed additional protocol number 2, are not applicable. And note how this is different from the interstate context in which any kind of hostilities, any kind of military engagement between 2 states would in fact trigger the Geneva Conventions and those rules that apply to international armed conflict. Now, this does not mean that we are in a lawless space here as regards these internal disturbances and tensions. Rather, this low-level intensity conflict still needs to be resolved in line with, most notably, international human rights law obligations, which we will talk about in a few weeks down the road. By contrast, the second scenario does trigger the law of non-international armed conflict, and specifically Common Article 3 of the Geneva Conventions. And the threshold here is that there needs to be a sufficient level of violence, but also that the parties involved, and particularly the non-state party that is challenging the authority of the state here, is in fact demonstrating a sufficiently high level of organization. Now, in order to understand how to evaluate levels of intensity and where exactly to put the threshold, we can consult the jurisprudence of some international courts, such as the International Criminal Tribunal for the former Yugoslavia, which in cases such as Limay provided us with a number of factors that could be taken into account, of course, on a case-by-case basis. And this includes the number, intensity, and duration of individual confrontations, the kinds of weapons used, the number of troops used and kinds of troops used, etc. This soon becomes a quite complex and technical exercise, but one that needs to be performed very diligently, notably by these international criminal courts and tribunals, such as the ICTY, because for them, of course, it is important to establish whether there was a context of an armed conflict if they want to find an individual guilty of a war crime. A brief side note on the organization of the group. This is not so much about what the government calls them, whether they refer to them as terrorists or insurrectionists. Rather, it is about the organizational structure of the party that is involved in these non-international hostilities. So, does it have a command structure? Does it have disciplinary measures that it can enforce to individuals, individual combatants that are not in line with the rules of this entity? And of course, there is some correlation with the intensity of the conflict here, because only a thoroughly structured, well-organized, disciplined, coherent group will be able to put up the kind of fight and the kind of level of resistance that rises to the threshold that is required for the law of non-international armed conflict to kick in. In the third scenario, then, the conditions of the second one are already met as regards the intensity of the conflict and also the organizational structure of the group that is opposing the state. However, in addition, this group also now has effective control over a part of the territory of the state in which it is based. And under such a condition, additional protocol number 2 comes into play and is triggered and therefore applicable if the state indeed has ratified it. The idea here is that the hostilities will likely be more protracted, that military capacities will be higher, and that military operations will be more concerted, better organized, and potentially also more violent. And this is why we need additional protocol 2 with its additional protections for the various individuals that require such protection. Importantly, and I will end on this note, additional protocol 2 explicitly does not extend recognition to the non-state actors that are opposing the government in question. So while they are obliged to follow the rules of engagement that are outlined in this instrument, this is completely without the prejudice to the outcome of this conflict, and it definitely does not imply international recognition for the non-state actor. And you can see here how this qualification was very important for all those states that eventually decided to join the additional protocol to sign and to ratify it. Past experience suggests that there may be quite some questions regarding, in particular, non-international armed conflicts, but I will leave it at this and refer you to our discussion in class for an answer to these questions. This concludes the videos for this week. I look forward to discussing all of this with you in class.